Now I am going to dictate a legal passage at the rate of 120 words per minute. Let's start. In the matter at hand, the present application has been initiated under Section 11 of the Arbitration and Conciliation Act 1996. Within bracket, the 1996 Act, the application seeks the reference to arbitration of a dispute that has arisen between the involved parties concerning an option agreement dated October 18, 2010, amended on July 29, 2011, which incorporates an arbitration clause. Para. The respondent disputes the contention made by the petitioner primarily on the grounds that the agreement is inadequately stamped. According to the respondent, the stamp duty payable as per the West Bengal Amendment of the Indian Stamp Act is significantly higher than what has been affixed on the agreement. The respondent relies on Section 38 of the Indian Stamp Act 1899 within bracket the 1899 Act to argue that the court cannot refer the matter to arbitration. In support of this argument, the respondent cites the case of NN Global Mercantile Private Limited versus Indo-Unique Frame Limited and others, reported at 2023 SCC Online SC 495 para. Furthermore, the respondent asserts that the application is flawed due to the non-joinder of the Special Purpose Vehicle within bracket SPV Odisha Steel Expressway Private Limited, which is a party to the option agreement containing the arbitration clause. The respondent argues that the SPV is essential to the proceedings as certain clauses in the agreement impose obligations on the SPV and any order or award may affect its rights. Para. The respondent's senior counsel contends that the petitioner's claim is a time-barred opinion out that the right to exercise the option under the agreement accrued on January 13, 2017, and the petitioner only exercised this right on June 1, 2012. After the expiration of the limitation period, the senior counsel refers to the case of Vidya Drolia and others versus Durga Trading Corporation, reported at within bracket 2021 to SCC 1 to support this argument. Para. Additionally, the respondent argues that a corporate insolvency resolution process within bracket CIRP commenced on March 30, 2017 after the option right accrued in favor of the petitioner. The petitioner did not file any claim during the CIRP, leading to the extinguishment of its claim upon approval of the resolution plan. The respondent relies on Vidya Drolia within bracket Supra to support this proposition. Para. The respondent contests the petitioner's reliance on an NCLT order dated August 30, 2022 in an application under Section 8 of the 1996 Act, stating that the said proceeding and order have no relevance to the present case. The respondent argues that the issues before the NCLT were different and did not relate to the purported option right of the petitioner. Para. In response, the petitioner's counsel contends that the claims is not time-barred. They argue that the obligations under the option agreement were novated by a letter dated July 29, 2011, in which the petitioner waived all rights or claims towards the option premium. The petitioner argues that the agreement remains binding until the respondent fulfills its obligations by transferring the option shares. Para. The petitioner also disputes the respondent's assertion regarding the option agreement's enforceability after the initiation of CIRP. They argue that the petitioner does not fall within the classes of persons mentioned in Section 31 of the Insolvency and Bankruptcy Code IBC who are bound by the resolution plan. Para. Regarding the insufficient stamp duty, the petitioner argues that only the principal instrument is chargeable with the duty and the transfer deeds can be treated as the principal instrument. They also express readiness to produce the original agreement for impoundment para. In conclusion, the petitioner contends that none of the respondents' objections is valid and the dispute is arbitrable. As per the option agreement, they argue that the respondent lacks grounds for refusing to nominate its arbitrator para. After hearing the arguments, the court delves into a comprehensive analysis of the option agreement's relevant clauses. It concludes that the dispute sought to be referred to arbitration is dead wood and non-arbitrable. The court emphasizes that the petitioner's claim is time-barred and extinguished, rendering the application under section 11 not maintainable para. Ultimately, the court dismisses the application and the judgment provides a detailed explanation of the reasoning behind the decision. The court also addresses the arguments made by both parties, citing relevant legal principles and precedents. Stop. Thank you.